Hi everyone, welcome to Active Self-Protection Extra, here again today with defense attorney extraordinaire Tim Forshey from Forshey Law. And I want to talk today about the process for somebody who's had their gun rights removed to getting them restored.
To win the fight after the fight, you need help. After a use of force, I trust Firearms Legal Protection to help me win the fight for the rest of my life. From their 24/7 attorney-answered hotline to coverage for the use of all legal tools, Firearms Legal Protection has you covered. Get a discount by signing up at the link below.
Tim, I know you as well as I are a Second Amendment supporter, and I'm a Second Amendment absolutist. The right of the people to keep and bear arms shall not be infringed.
What don't you understand about
Yes,
that?
it's very simple phraseology. However, with due process, right, as long as we have due process that's appropriate, then someone's rights can be removed. Here, basically across the country, if you commit a felony,
Any felony
whatsoever, or misdemeanor domestic violence,
that entails a threat of violence.
Right.
So in theory, criminal damage to property where you smash your girlfriend's telephone is a domestic violence conviction, but that should not result in the loss of your gun rights.
but if you throw the phone at her,
That would be different, correct?
different issue.
Yep.
So generally speaking, those happen. But of course, I mean, goodness sakes, we all commit felonies, and on the regular, it just depends on which felonies you're comfortable committing, quite frankly. And I say that I'm not even in jest. I mean, there's so many felonious things out there that you can't really do. You can't live without at some point committing felony. But of course, you don't get hemmed up for it because you probably don't get caught on it. But if you do, and then you do your time, and then you get out, and how do you go about getting your rights back?
Well, there are certain felonies that you can't. So we didn't prep this, so I didn't do the research. I believe it's ARS 13. I want to say 897, so I'm probably wrong. So
I jumped him on this, guys. So
those
we'd have
of
to
you
look
tell
up
me
the
that I'm wrong,
statutes.
you're right, I'm wrong, but it's in that ballpark.
We'll look it up and I'll put it up in a graphic.
But basically, there are certain types of felonies that cannot be set aside in the state of Arizona. Crimes against children, any crime that's designated by the statute as a dangerous crime. Those cannot be set aside, okay? Now, that's not really too many felonies, really. But in the grand scheme of things, that's not most. I see ag assaults that we managed to avoid a dangerous designation. So so it provided that it doesn't fit into that statute, so there's not a statutory ban, then the process is actually pretty simple. You actually file a motion to set aside the conviction. Now, before that's even plausible, you have to have done everything required by your conviction. So you have to have paid all of your fines, you have to have paid all of your any recompense that was due to the other side. You have to have completed your probationary terms, done all of your counseling. Everything has to be completely done.
Every box checked.
Every single box must be checked before you can even really try, right? And then it's a matter of time, okay? The right judge maybe would grant that restoration of rights quicker. Some judges won't. I will say this because it's a matter of public policy. When I was a judge in Scottsdale, we unfortunately prosecuted a lot of public urination cases as a misdemeanor.
What's Scottsdale? What is wrong with you?
Come on, it's public urinate. We all urinate. But it would be usually, people down at the bars, on a Friday or Saturday night, and there's a long line of arrests. They've got to go bad, so they take a leak in the bush, and some cop sees them do it. They would come in, and believe it or not, that's a Class 1 misdemeanor under a city ordinance in Scottsdale, equivalent to a DUI. And we would almost always, they would admit it, we would assign a fine. We would tell them, go out and pay your fine, come back in with proof that you paid your fine, and I will set aside your conviction. We would do it right then. So depending upon the nature of the crime and the philosophy of the judge, in my case, the philosophy of the judge's boss, it's not that big a deal to do it. So if
we want to discourage peeing in the bush, but we don't want to hem people up.
Yeah, we don't want to make them have to admit they're a criminal the rest of their life because they peed in the bush when their bladder was about to explode, right?
Yeah.
So you got to and really I think the same thing applies for felonies as well. It kind of depends upon the felony, right? If it's a pretty bad felony, then probably the judge won't set it aside. Maybe not immediately, but you can try again. One of my favorite stories, I just finally got a client his rights back last year. And it was the 4th time that we tried to get his rights back.
Wow.
And he was very diligent about it. And he had spent over 20 years in prison on some drug charges. No violence, but he was clearly had a very serious drug problem. And he turned to dealing in order to finance his problem. And he got caught. He was horrible at it. And he ended up doing 20 years in prison. And when he got out, he started a business. And his business would have been able to flourish if he'd been able to get his rights back. That's all you need to know. And I said, it's going to be a tough haul, man. But we did everything we could, and it was denied. And then every year, on the anniversary of the denial, we resubmitted, added new information to it, resubmitted it. On his 4th attempt, he got his rights back.
Wow.
And I just think that guy's got, he's got more get done than I do. I was really applauding his efforts there. But it's largely a matter too of focusing on how the person has rehabilitated themselves. So, okay, I had a drug problem, I was in prison. Well, I was able to show that while this guy was in prison, he got a college degree and he got all these other degrees.
Drugs.
He was teaching these classes, he was drug-free, he was in AA and Narcotics Anonymous. He got out of school, he got out of prison, started this business, flourished with the business, was servicing all these different contracts. He had a federal possibility contract that he couldn't get with a felony. Had all these contacts from people. He had a family. He had a kid that was going to school. Suddenly he put his life back together. He was a success story, right? And so we show all that. We get all the pictures of the graduations and all the pictures of the weddings, the high school diploma,
right,
the
this
college
is a
diploma.
good person now.
It's a good person now. And we show all that to the judge. We might have a 10-page pleading with 150 pages of attachments. And we send all that to the judge. Look, this guy has put his life back together. Can we give him a chance to put it back together in total? Can we give him his rights back? And that's kind of how you sell it. And I think if you sell it right, my success rate's pretty good.
Now, is there a devil's advocate, like a prosecutor?
The prosecutor can oppose, and oftentimes they do. But frankly, you can kind of tell by the nature of their opposition whether they really oppose it or not, right?
They kind of have to on policy.
On policy. They're not going to say, yeah, this guy can have his rights back. But usually it's a 1 or 2 page pleading where they just say, yeah, this guy shouldn't have his rights back. And oftentimes the judge will grant it even over that. Oftentimes the judge will set it to a hearing. And at the hearing, the prosecution will oppose that. Of course, I'll advocate that. My client will be there as a witness. If there was a victim and they're still around and they still have some spite in their gut, then the victim may be called as a witness by the prosecution and it'll be contested. I think when it's hotly contested, if there is a victim, if there was any violence at all, the chances aren't that great. But if it's no blood on the ground, no threat of blood on the ground kind of a case, and you really have turned your life around in Arizona, that's very doable. Now, in other states, it's a whole different conversation. My home state of Illinois, that I'm so glad to call the state that I'm from and not the state that I'm in, has a process where, and it's ironic, and the only way to get a felony set aside in the state of Arizona, Illinois, to my knowledge, is to seek a gubernatorial pardon, which is always kind of interesting because half the ex-governors in Illinois are in prison. I think they have at one point 2 ex-governors and two ex-attorney generals.
I thought the office of governor in Illinois was a pre-prison program.
That's what it is. Yeah, they're prepping you for prison. So I think that's ironic that that's the only way you can get it set aside. But so different states vary, and of course, if you're an Arizona resident now and you want to get that felony from California from 1973 set aside, you're going to have to get an attorney in California to get the conviction set aside in California. I can't help you here. So,
do you have any idea? Could you give us a ballpark on what it's probably going to cost somebody to do that?
I try to do that as fair as I can, and I call it bifurcated fees. So I charge you a fee to do a flat fee. I don't usually do it hourly. A flat fee to prepare the pleading, put it all together, and get it filed. If the judge grants it or denies it at that point, there's no need to pay me anymore, right? And we just try again later if you want to. And then if we do have a hearing, then I'll charge you another fee. Once I kind of take the pulse of the prosecution, know what I'm up against, then we'll sit down and we'll talk about a second fee for the court appearance. You're probably looking at in the ballpark of $2,000 to $5,000 for each of those 2 phases in that ballpark. So if it's a relatively simple case
could be $2,000.
Not a whole lot to say. It could be $2,000. It could be $5,000. I mean,
could be
obviously
10.
It could be a weird case where it's a lot more, but I would say the vast majority are closer to 2 than they are to 5. Yeah.
Well, and of course, you heard him talk about this man who did 20 years and then started his own business. Why? Because he probably couldn't get a job because he's a felon and it's on his record.
Yeah.
And so he started his own business and trying to do things. And this is personal stuff to me. I have a friend who has a pardon sitting on the governor's desk of a state right now that he's a different man. And he's a different man than he was.
Sometimes it really does work. They do get
really does. I have another guy who's an acquaintance, came to my church for a while, did every day of 25 years for capital murder.
Wow.
Had a death sentence commuted or expunged through they overturned on appeal, and then when the state retried, he had actually come to faith in Christ on death row.
Wow.
And then his attorney said, don't say a thing without your testimony. They can't convict you. And he said, but I did it. I killed the guy. So he walked in the judge's chambers and pled guilty.
Yeah.
Did every day of 25 years. He's been out for about 15 now or so. And he's a fantastic human. He does great stuff now. He's got a wife and young kids, but he ain't getting his rights back.
Yeah.
Not with that kind of thing. So, I mean, this is personal stuff. And I think you can turn your life around. I don't think prison should be the end of things. I'm kind of the mindset that man, if I don't trust you with your rights, then why are you not still in prison?
Yeah, if I can't trust you to be a productive member of society, you should be locked away like a bad dog.
Right. If you're a bad dog, then we keep you locked in a cage.
Right. And no, we don't hate you for it, but this is just better
you're dangerous.
Exactly, you're dangerous.
And I think we need to change that, quite frankly. I believe that you should have an automatic process for this. This should just be maybe after a number of years. You know, if 5 years after release from incarceration after a felony, as long as it's maybe not, violent against a person or something. Then
well, there's some talk of doing that in the state of Arizona. Right now, you don't lose your right to vote until your second felony. And there's some talk about, again, leaving the dangerous crimes out of the talk. There's talk about doing the same thing with firearms rights in Arizona, restoring them on automatic set aside of that provision. So,
I don't know why we don't do that.
Yeah, so, I think that's coming.
So that's the process. Don't get jammed up for felonies, friends, because it's expensive and bad. Yep. And then when you get your rights back, it's difficult and onerous. So don't do it.
Yep, don't do it. Like a lot of this stuff.
Thanks, Tim.
You bet. My pleasure.